Good afternoon here in Japan. My name is Sop Choi, and I'm from Hankuk University of Foreign Studies in Seoul. And actually, I'm visiting Kyoto University. And first of all, I would like to thank Professor Wakui Sensei for kind invitation to this university. At the same time, provided this wonderful event. My presentation is not really like, let's say, very interesting because I'm not going to talk that much about cases, just theory and some possible consequences from the implementation of some regulations and provisions. So might be boring, but I hope it would be worthy. I'm typical Korean, so one of the Korean cultures is like 빨리, so it's like quick and fast. So I speak fast, but I try to not to today. So if you have any question, then just raise your hand, and probably we can have a kind of yeah, some small discussions in the middle of my presentation. So this is content. It's really short. But I'm going to talk about the process effect. So I believe that most of you guys know about the process effect. So I'm going to talk a little bit about the some issues of the harmonization and convergence of the policies and regulations. And the second part is about the data portability and competition in the digital market. So this is a general introduction to the importance of the data portability and how it may impact in the market. And the third one is a bit boring, especially Thomas is here, and this is just an introduction to the European regulations and provisions on the data portability, and some cases about the Article 102, especially in Italy. And number 4 is about Korea. So Korea actually has adopted the new provision on the data portability, and it's possible that the competition law can have some roles to improve the data portability in the market. So that's the number 4. And number 5 is like still we need to think about some kind of the criteria or standard in assessments of the anti-competitive effect in the data portability, and especially in the market like data ecosystems. And then I will wrap up today's presentation in the conclusion. So process effect. So we all know about the recent developments in the EU, especially digital regulations. So we know the General Data Protection Regulation, Digital Services Act, and Digital Markets Act, and the AI Act. Based on the famous textbook written by Professor Bradford, so the name is like process effect. But we can see really significant similarities between regulations. Actually, I'm having like not many audiences in the room, so just you. So well, I feel like I'm just speaking through only laptop. But anyway, yeah. So I can see some similarities, but quite differences between countries and regimes. So I can say that this is kind of their localized process effect, or maybe the Seoul effect. That the name is not from my own idea, but like Bradford's second book is Digital Empires. She talked a little bit more about the Washington effect or the Beijing effect. So I can quote this is kind of the Seoul effect. So I can say this is kind of the localized kind of the approach in Korea. So there are 3 issues. First one is data protection law. So Korea also has the Personal Information Protection Act. So the acronym is PIPA. And also, the Korean competition law is Monopoly Regulation and Fair Trade Act, so MRFTA, but I could say just competition law. The last one is AI Act. So similar to the European Union adopted the AI Act last year. The same. So the last day of the 2024, even though there are some kind of the political situation, as you may know, impeachment. The parliament actually passed the new proposal. There was the Korean Beijing AI Act, and there are some similarities but differences. So when you compare the those 3 parts like data protection law, competition law, and AI Act, but I'm not going to talk about the AI Act today, but just two parts. There's the data protection law and competition law, especially focusing on the data portability. So there are some critical issues in Korea. The first one is the PIPA provisions on the data portability. Very similar to the GDPR Article 20, but still very different. So I'm going to talk a little bit about the differences between those two provisions. Second is no DMA style regulation in Korea. There are some proposals and talks about the DMA type of the new digital regulation or the amendment to the competition law, similar to the DMA kind of the designation. But those proposals do not include kind of the data portability. That is different from the DMA. So at the moment, it's not really clear whether Korean Parliament will adopt the new regulation like DMA or not. But it doesn't matter. The proposal doesn't include the DMA's data portability. So the last one is also the some issues like about the no case. That means there's no case whatever about privacy or data portability under the competition law, and we need to think about the refuse to deal case at the same time essential facility, whether data is kind of the essential facility or essential data, indispensable kind of data, where it's kind of the big issue and difficult kind of the question. Data is power, so we all know that the data is very important in the age of artificial intelligence. So Korea, actually Professor Wakui and I talked a little bit about the Korean economy last night, but we Koreans prefer new technologies and new trends of the kind of the platform and businesses model, and yeah. So actually a few years ago, Korea adopted the data portability only in the financial sector under the Korean Financial Information Act. So that's the Article 33, paragraph -2. So it's really popular. So based on the newspaper, actually over the last 1 year, actually the number of the users increased like double. So that means like almost everyone is using data portability between financial companies. So that means like there are so many kind of the not so many, but I think I didn't count, but I think the little bit more or less like 50 platforms, like including the public sector, public kind of the companies. So there are a number of the fintechs, banks. So that means like, I can just control all my assets through the one app. So through the data portability among the financial sector. So, but Korea tried to expand not only from the not only financial sector, but the all different sectors. That's the amendment was actually that was made a few years ago, but it's not really effective now. They have to establish the some kind of the interoperability kind of system like API, so application programming what's that interface API. So that's the one of the challenges the authority has now in Korea. So the next point is about the intersection of the PIPA and Korean competition law in the area of the data portability. So this issue has been discussed in Europe a lot, actually. But in Korea, there's no kind of the close coordination between regulatory agencies. So it's going to be a really big issue in the near future. So the first part is data as a fundamental right. So it's really obvious that under the Constitution, data is really data privacy actually is very important from the data subject perspective. So it's like freedoms and the fundamental rights. The second issue is about the product. So data can be understood as a kind of product. It's like it's can be a kind of the single product market. So there are kind of the issues about the interplays between two different kind of the laws and subjects and concepts. But I can say that the provisions of the data portability can directly ensure the rise of the data subject, and at the same time indirectly improve the competition. So it can enhance the welfare of the data subjects as consumers and also the end user. So there's no distinction between sorry, data subject or the consumer or the end user. They are all the same people. So data portability is really important. So the first one is about the right of data portability under the PIPA. It's about the guarantee of the rights and freedoms of the data subjects. And the competition law is about the protection of the competitive process. Well, Korean competition law can cover almost everything. Like public interest is like really wide. So I could not say protection of the competitive process is the only goal, but sorry, I'm speaking too fast. Well, so let's look at the European approaches. So, well, GDPR, DMA, and Article 102 TIF can be applicable to data portability. So, what about the other countries? Well, again, it's like localized convergence. So that means like well, when I just look at the Korean data protection law and competition law, there are so much similarities between those two, but still very different. Especially Korea doesn't have any DMA. And yeah, so the next point is about the three topics. So three important kind of the questions. Sorry. The first one is the objectives of the competition law and data protection law, whether those two can widely cover kind of the consumer welfare innovation, competitive process, public interest, and non-economic goals, where especially the scope of the competition law, especially in Korea, has expanded a lot widely. Doesn't matter it's like a neo-Brandeisian school or not, or Chicago school, but still it's like they don't care that much about the which is theory, but like from the historical perspective, actually Korean competition law has been applied so widely to almost everywhere, every areas of the and sectors. Second is question is about the possibility of the applying competition law to refer to transfer data, like data portability, especially focusing on the essential facility doctrine, which is a really tricky and difficult question. So especially a few days ago, actually there was a Court of Justice of the European Union delivered the decision judgment about the Google car case, about the kind of the interpretation of the Article 102 based on the Oscar Bruno kind of the criteria, and some people were happy, the others were not. So that means like still Oscar Bruno kind of the criteria is like really high, and that means it's not really easy to bring a case against the refuse deal, especially data thing, because of the data has some kind of unique characteristic like non-rivalrous and non-exclusionary. So it's not really gonna be really easy. And third one is reference of the PIPA provision for deciding violation of the competition rules. This is a really critical issue. So, well, my argument here is like, we can apply, possibly in theory, apply the rule on unfair trade practice, like UTP rule, because again, it's not really easy to provide, especially for the competition agency, to provide the evidence of the essential facility or indispensability of data in the digital market. So the alternative ways, like to apply the UTP rule. Well, over the last 10 years, actually, I have argued pretty much against the UTP rule. So that means like, well, we have to reduce the scope of the UTP rule, and maybe we have to combine rule of the object market dominance and UTP rule all together, and to make a simpler and But in the meantime, well, I need to accept that. Well, still there are some rules for the application of the UTP rule. So for that, well, I need to make a theory. So I need to theorize a new concept for combining the two areas of the law, like data protection, privacy, and competition. So actually, this is all I want to talk today. So just in case if we run out of time, then this is my argument. All right. The second part is like really basic. So well, there are some kind of the benefits like positive effects from the data portability, and there are some kind of the negative effects from the data portability. So there are first, if I just talk about the benefits, like data portability can improve the rights and freedoms of the data subjects. That's so obvious. Some people just argue that the about the data ownership, whatever. But simply anyway, it's under the constitutional law. It's like really important kind of the part. And second is like data portability may improve the innovation and competition, because I mean it can really allow the new entrants to access to the essential data, certain data. So then entrants can have a chance to enter into the market. And the last point is like a data protection law establish the market entry barrier. That's so obvious. So some companies cannot comply with the data protection laws because I mean when you look at the Korean data protection law, is there are too much like very stringent kind of the provisions. So some companies cannot comply with the data protection law, but the the data portability can provide some kind of trade-off effect. So that means like the law itself is like an entry barrier, but this provision data portability can allow market entry. So it's kind of trade-off between those two. There are some more, but I think those three are important. And again, there are some shortcomings from the data portability. It may generate a free riding problem. So that means like entrant can have a chance to collect data without improving any kind of the portable services. So eventually it will lead to the failure of the investment. That's going to be really bad. And the second point is like it can mislead the data subjects as consumers or the end users to transfer their data to unqualified controllers. So basically, if it's really fascinating to all the platforms, then platforms will just focus more on inducing users to transfer data, even though it's like because consumers do not have enough information about the consequences of the transfer data, right? So it's going to be really harmful to the consumers. So there are some kind of consumer protection issues. And the next one is about the it may establish the other entry barriers, especially in Korea, because I mean the Korean provisions set some kind of the requirements on the controllers like platforms, for the data portability. So that's gonna be another issue in Korea. And the last one is without a sufficient level of the portability standardization for all the sectors, and the system may function as a discriminatory. So that means like some companies cannot comply with the standardization, then API again, then it's gonna be another entry barrier. So my questions are like it's like another like small questions. Like the first one is effectiveness of the data portability. So we need to ask whether the end users or data subjects are familiar with the data portability systems and consequences. Well, actually, already know that the GDPR has become effective in 2018, but over the last 7 years, I haven't seen any notable exercise of data portability in the single market, which means like there's no real kind of the practice and effectiveness in Europe, which is really different from the Korea, because I mean Korean users are really like I don't know, they just fascinated with the new technologies, so they just prefer the convenience and like so they just almost all like use the data portability in the financial sector, but that's not in the EU. So we really don't know the real consequences, because if there's examples in the EU, then we can predict the possible outcomes from the Korean data portability practice. But The second is, again, technical issues like standardization. So we need to ask whether sufficient technical standards exist for the interoperability. So Korea already adopted a system like API system for the financial sector, but it's not really easy to build all systems for all digital sectors. It's gonna be really costly, and there are so many interest groups, and they prefer certain things, and others are not. And the third one is user switching cost. So we need to ask whether users and the users have incentive to switch their services through data portability, because some platforms, some entrants do not have any capability to deal with their data security or cyber security. So it's going to be really kind of the risky, and also their services are not really fast enough sometimes. So services the qualities is not really superior. In the case, then people will not switch to new entrants. Okay, so next one is really boring, but I need to talk because we have only one European scholar, but the rest of them are not from Europe. So the first part is GDPR. So Article 20, paragraph 1 states that a data subject has the right to receive her or his data that the data subject has provided to a controller, and the right to transfer the data to other controllers with certain conditions. So this is like from platform to platform and to the data subject. And paragraph 2 says that the data subject has the right to have the data transmitted between controllers, like between platforms. And also the right to data portability should not harm other data subjects' rights. So it's obvious. It's under the Article 20, paragraph 4. And I can just say that the Article 20 GDPR underlines focuses on the assurance of the data subjects' controlling power over their own data, especially if the data subjects, like as consumers, do not have any bargaining power in the terms and conditions. And next one is a DMA. So Article 9, paragraph 9, Article 6, paragraph 9 is about the obligations. So data gatekeepers, actually designated gatekeepers, should, upon the request by an end user or the third party authorized by the end user, transfer the data provided by the end user or generated by the end user's activity through use of the gatekeeper's core platform services. So you all know about the designation criteria under Article 3, right? Like turnover and number of users, and also the list of the core platform services like OS and searching engine. And the gatekeeper should deliver a data portability service that is free of charge, and also the some tools for effective kind of the data access. So actually there is a kind of the possible overlap between Article 20 GDPR and Article 6 DMA, because the controller is obviously gatekeeper, right? But actually, a European Commission has jurisdiction over DMA, and the national competition authorities, member states authorities have jurisdiction over the GDPR. So I don't see any significant conflict between those agencies, but it's not likely in Korea. The third one part is Article 102. So Article 102 can be applicable to the abusive conduct, especially related to the prohibiting data transfer by market dominant undertaking. So we all know that in the very beginning of my presentation, where we have seen some different goals between competition law and the data protection law. So they are different. But the GDPR can be an important benchmark or the standard in deciding whether a conduct can be a violation of the competition law. There was a case, so interesting case. So, especially in Italy. So Italian competition authority actually investigated the whether Google's conduct of the obstacles to interoperability in data sharing violated the Article 102. But unfortunately, actually this case investigation was closed because I mean the agency accepted the Google's commitment proposal. So, but I think this case is really bit important. I mean, if you just look at the this case, there are only just few pages because it's you know Italian authority just published the case 2 page long. So, well, there are some kind of lack of the information, but still we can use the that one. So it seems that the Article 20 data protection, data portability provision can be a main kind of the element in deciding whether refusal of the interoperability for transferring data may influence the competition law. So the Italian agency argued that the data portability was a very important element in the competitive pressures. That's really important because I mean, well, incumbent can face kind of threats from the data portability. So the the incumbent kind of the gatekeeper may control the whole digital ecosystem. Then maybe it's gonna be really good instrument, antitrust instrument to solve the kind of problem. So the Italian agency again argued that the right to the data portability accompanied with the interoperability instruments could help the end users obtain benefits from their own data. So the authority focused on the two things. First, consumer welfare and market entry, eventually improve the market contestably. That's the aim of the DMA, but I don't know, but Italian authority talk about contestability here, even though the DMA objective is totally different from the competition law. So because this case was closed by the commitment decision, so it's a bit difficult to conclude whether the only conduct of the constraining data portability confirms a violation of the Article 102. But we already saw a meta judgment, right? German Facebook case and CJEU actually delivered the judgment. So the court held that the German competition authority or maybe member state agencies could take a data protection law GDPR into consideration when deciding a violation of the competition law. So that's gonna be a really good kind of the guideline. So next one is, it was quick, right? So I can be slowed down. Yeah, a little bit. I'm typical Korean, so well, Korean professors normally they speak really fast because they think they have to talk sufficient level of the information, otherwise can mislead the audiences. Yeah, so I can slow down. Right, I'm gonna talk about the Korea. So again, well, we don't have any DMA regulation different from the Japan. Japan has I saw the Professor Wakui's publication online. Journal of European Competition Online Practice is already online. So it's about the Japanese smart OS, but we don't have yet because it's really critical in Korea. I mean, some people just prefer the competition law rather than sector-specific regulation, and regulatory agencies sometimes they make some kind of conflict between those two because they argue that the certain digital sectors are their jurisdictions, whatever. Second point is no case law related to the data privacy. So that means no competition law. Like there's no a German Facebook case in Korea. I mean, well, the data protection agency in Korea actually applied the data protection law and imposed the huge fine on Meta in the same case, but not the competition agency. So that means there's clear border between of the jurisdictions between data protection agency and competition authority is not likely in Europe. So there is no coordination. They are enemies, like frenemies. Yeah, frenemies are not only between platform companies, but agencies in Korea. So Okay, so I made some theorization. It's like a new concept of the order liberalism. So we all know what the order liberalism, right, from Germany. So that's really related to the social market economy and economic democratization, especially Article 119, Paragraph 2 of the Korean Constitution declares economic democratization. Initially, actually, to regulate the conducts of the chaebol companies, but nowadays, it's not likely. But still, it's like written in the Constitution. So it's basically from the older liberalism. So I can say that the well, order liberalism is like older kind of the theory, but can be applicable to the digital market or digital society. So I can say that it's kind of new concept of the digital order liberalism. So in Korean, it's a digital 질서자유주의, or in Japanese, 디지타루秩序지유주의. Maybe. But anyway, so this is my new argument. So this is actually heart of the my argument. So protection of the economic and fundamental freedoms and protection of the fundamental freedoms. Fundamental rights and freedoms. Sorry, it's typo. Politically and economically of the individuals or data subject from abuse of large platforms with a superior bargaining position at the same time from the state or government. So we talk about the fake news and Digital Services Act and harmful contents, and I think those are also a part of the digital order liberalism. I'm not talking about the European, but Korea. I don't know about the Japan or the other countries, but like in Korea, we talk about a lot about the fake news and impeachment cases ongoing now, and there are some kind of the harmful contents and fake news and stuff. So eventually we need to talk about those kind of issues, but it's again we can use this theory. I can just introduce the data portability in Korea. So I already talked about the financial sector is based on the Financial Information Act, but PIPA is different regulation. So a few years ago, we amended the PIPA. So Article 35-2, Paragraph 1 states that a data subject can request a transfer of personal information from a controller that satisfies certain criteria. So that means like not every controller. This is different from Article 20 GDPR because it can apply to the older controllers, but in Korea, only certain controllers that satisfy certain kind of the requirements. And such as the controllers, the ability to process personal information, and that is under the enforcement decree of the PIPA. So if you are not really familiar with the Asian or Korean law system, but actually we have regulation law act, and there are supplementary kind of the legally binding kind of the provisions, like they are enforcement decrees or presidential decrees. Yeah, it's kind of the preamble sometimes, but yeah. So this act, this provision was adopted a few years ago, but still it's not effective because we haven't decided the standardization and technologies for the interoperability. So if we set that kind of the policy directions, and then we will amend the enforcement decree of the PIPA, and then this provision will become effective. But it takes a really long time. The next part is like, again, well, similar to the Article 20 GDPR, the Korean rule actually, sets out, kind of specific conditions for the data portability. So I can say that the personal information for transfer should be the data subject own, and it should be processed with the consent and be transferred at the request of the data subject for performing or concluding a contract. So if we just look at this paragraph 1, then this is example of the process effect in Korea, but different. So the same provision, paragraph 2, articulates that a data subject can request that, sorry, this is blocked, his or her personal information be transferred to a controller that satisfies the certain requirements under enforcement decree, including turnover, scale of the personal information retained, and capability of the data processing, industrial characteristics like or the sector kind of the characteristics, and other relevant factors, especially related to the technical feasibility and reasonability. So the controller that can receive data or transfer data should be an institution that specializes in managing personal information, or a person who fulfills the obligation under the law and satisfy the necessary requirements, such as the sufficient facilities and technologies. So there are some entry barriers, just like I said in the very beginning of the presentation. And those criteria actually show a different approach from the Article 20 GDPR, again, as the Korean standards may influence the market entry in the digital market. And the next point is like if a controller does not satisfy the conditions that limit the effective data portability, actually this system may not enhance its data collection. So the qualification is really important, and it can possibly make the single homing or lock-in effect. But I can understand why Parliament adopted this unique provision different from the GDPR, because again, well, to protect the data subjects, because there are some differences between European, maybe I cannot say differences, but where Koreans focus too much on the protection of their weak people, especially consumers and small companies. So this is it's kind of the inevitable, I think. So to protect the data subject as a consumer. There are some other kind of the provisions within the the PIPA. So paragraph 3 of the Article 35-2 again is about some kind of the safeguard. So it says that upon receiving a request of the data portability, a controller should transfer the data in form of the accessible through the computer or the other processing device to the extent reasonable in terms of time, cost, and technology. So that means like a trade-off and balance of the interest between controller and also the data subject. And paragraph 5 is about it says that allows actually controllers to withdraw data transfer. This is also different from the European provision, but upon the request of the data subject. And paragraph 6 permits the controllers to refuse and suspend a data transfer request, especially when they cannot verify the real data subject's request. And paragraph 7 prevents any infringement of the other data subjects' rights and interest. So that's the same as the GDPR. It blocks my statement. So, so my conclusion is like if you just look at the European and Korean, there are some similarities and differences. And so one of the major differences between Korean regime and EU regime is that the Korea has not adopted any law targeting, just not like Japan, targeting digital gatekeepers, especially related to the data transfer and data access or interoperability. That's the big difference between those two. And the third point is like, the Korean provision, Article 35-2, is not fully effective yet. So it's not really easy to examine any possible competition case, especially I told you about the German Facebook case. Actually, the Korean Data Protection Agency won in the case in the Supreme Court. So, but they never thought about any kind of exploitative abuse under their competition law. So there's no such case, and data portability may be the same issue. So the only relevant case for the efficacy of the competition law for data portability is the Italian case. So on the one hand, actually, Italian Google case can inspire application of the competition law, relying on the data portability under the data protection law. Because data portability or interoperability may solve the problem of the lock-in effects. And at the same time, on the other hand, well, DMA approaches to the gatekeepers may also provide some ideas, right, for effective implementation of competition rules without obtaining the DMA-style regulation. So 3 choices in Korea, like first one is a PIPA provision, or the abuse of market dominance, or UTP rule. So there are 3 issues again. First, harms to competition, which means harms to freedoms of the data subject. So there's a strong kind of intersection between those 2, like competition and data protection. So that means we need to allow kind of wider scope of the competition law. And that's based on the theory, jitter order liberalism. Second is a test of the essential data. So, well, again, each country has a refusal deal case, right? So EU has Oscar Bruno case, and US has the Trinco case, especially essential facility, and Korea has POSCO case. That's the steel producer in Korea and has huge market power. And this case was issued in the year 2007. Suddenly confused, 6 or 7? I think 7, right? So yeah. So but in the case, the Supreme Court didn't talk about too much about the essential facility. It's a really simple requirements of the evidence. But anyway, POSCO won in the case, and the KFTC lost. But there's nothing similar between Bronner and POSCO, or Trinco and POSCO. That's the difference between those 2. So especially it's not gonna be easy to say, well, the refusal to transfer data is kind of the essential facility doctrine. It's like an application of the rule of the own abuse of market dominance in Korea. It's like, I don't think it's gonna be possible. A third one is a clear guidance for the rule of the competition law. So if a controller, doesn't matter it has the market power or not, uses its data advantage to make it difficult for its rivals or competitors in the market. And this could be due because of the implementation of the data portability provision. Then the provision on fair trade practice couldn't be applicable. So that's the my major argument based on the digital order liberalism. But we need to think about the if we just allow too much, allow the law of the UTP rule too much, then it's gonna distort the market competition, I think. So my suggestion is if the refusal to transfer data does not include such an unfair harm, so we all know that the criteria of the unfair harm, right? So the PIPA provision should be applied, because data portability under data protection law is not about the right of the controllers and platforms, but that is about the right of their data subjects, right? So we have to distinguish some borderline between provisions. And there are 2 further questions to apply the competition law to the data portability. And the first one is, can data be considered an essential infrastructure, and not like a facility, but somehow in data ecosystems, and as such be a source of their competitive advantage over rivals or their trading parties and market power. And second question is about market foreclosure and their raising rivals' cost. So those 2 will be very important in digital ecosystems, I think. So this is the some kind of the I drew the line. So basically, order liberalism is foundation for the application of the rule on data portability under the PIPA, and at the same time the competition law. In theory, it's possible to apply competition rules, both like rule on the abuse of market dominance and rule on the unfair trade practice. So number 5, I was really fast. So still we have the 40 minutes. So probably I'm gonna spend like 50 more minutes for the presentation, and then I'm gonna have the training. Well, number 5 is about the criteria of assessing anti-competitive effects in the digital ecosystems. Well, I can see some typos, but like actually, I would try to say overall anti-competitive effects, and they include the market foreclosure, raising rival cost, and imposing the certain disadvantages on the certain specific undertakings, and the reinforcement of the single homing and entry barriers, and especially economic concentration or like gatekeepers kind of power, like monopoly power, and possible leveraging effects, especially in the digital ecosystems. So I can say that the in the Korean antitrust arsenal, so maybe our UTP rule can be on kind of the very important antitrust instrument or weapon to ensure effective data portability. So this is a simple kind of the criteria, but I haven't decided yet though. So maybe I have to delete some parts or add some parts, but I just put the certain kind of the criteria here. So if there is a refusal to transfer data, so obviously Article 35-2 PIPA could be applicable. But if there are some more kind of the harms, not only harms to the data subject, but also the certain undertakings, then the Article 45 can be applicable. So the competition authority or plaintiff need to prove the evidence of the unfair harms. So like disadvantages or discrimination, foreclosure, raising rival costs or switching costs and network effect, and some other kind of the elements. There are more, evidence for the application of the Article 5 Monopoly Regulation and Fair Trade Act. That's the rule on abuse market dominance. So first, again, refuse to transfer data, and the existence of the market power, like market dominance. So the agency need to define the relevant market, and then possibly examine the the other elements like anti-competitive harms, like exclusionary harms, and market foreclosure and the other kind of the elements, and market concentration, entry barrier, and consumer harm. Then maybe agency can apply the Article 5. So this is conclusion. Well, the process effect has been really important in many countries. It's like so obvious, especially we have seen influence of the European ideas of the regulations and policies in the digital market. That's so obvious. And but the problem is like well, there's no identical provisions or regulations between countries because we all have different kind of situations, right? We have different backgrounds, and well, market economies are different, and the constitution are different. So it's always about localization. So even like when I just look at the certain Asian countries and their competition laws, like especially Singapore, Malaysia, and India, they have experience of the UK colonial time, and then UK competition law, or maybe EU competition law, well, like implemented like implemented like in those countries, but like well, still there are some differences between those two. So it's all the same. Even like well, Korean competition law actually when I just look at the back 1980 when the Korean people adopted the new competition law at the time, the first type of the competition law. Well, we had a chance to look at the all different kinds of the competition laws in the world. So major part was like Japanese. So especially we look at the Japanese UTP law, and especially the regulations on the large conglomerates like Jabil. And we had a chance to look at the European because we saw that's why we adopted the rule on option market dominance, not monopolization. And also the we had a chance to look at the American, U.S. Sherman Act, especially Section 1 is like about the cartel. So it's a kind of mixture between from the all different countries. So we have a really strong kind of the provisions, but still, well, anyway, it's about the localization. So we had to change or amend or different ideas like about competition law and applications at the time. I think so over the last 40 years we have developed the implementation of the competition law. So different tracks like from Japan or the EU or the US. So it's all about the diversity, right? Diversity can provide some better ideas to other countries. It's not about uniform. So again, market power. When you think about this is also typo, sorry. But when you think about the market power in the in traditional market, is traditionally is like a high price and exploitative abuse because it's like based on the Adam Smith and it's about the welfare of the consumers. When we talk about the market power in the digital market, not the traditional pipeline market, it's just digital market, then it's nowadays we talk about the not high price because they don't provide the services with the high price, right? It's zero price services. So about the data privacy and exploitation and freedoms and the rise of the data subjects. So there are some kind of we need to think about all those. We need to think about a new concept that can cover the those issues. So that's why I talk about the digital order liberalism. Next point is like the competition rules. The role of the competition law should be limited as like supplementary or ancillary to the effectiveness of the data portability under the other pipeline. So I'm not saying competition law should be applicable to all the data portability case, but if it's not really working well in the market, I mean, the pipeline doesn't work properly in the market, then competition law can be possibly applicable. So that's my argument. And the next point is like still we need to establish the specific criteria. So I provided some suggestions, but that's not the final conclusion. Just I need to think about the other criteria also. I need to delete some parts, but so still it's really important to establish the criteria for the implementation of the competition law in Korea for data portability to avoid any overlap of jurisdictions between two subjects of the law. And again, the last point is like really critical to Koreans because we have seen so many conflicts and arguments and fights among the regulatory agencies in Korea. So, we need to think about the close coordination between those enforcement agencies. So that's why in the very beginning I just said that this topic is not really popular in Korea. The reason is like data protection agency will not be happy about my presentation. Maybe competition authority, yes, but data protection agencies like may think like it's kind of nonsense. But yeah, that's my argument. So anyway, we need to think about the sharing some ideas. Like thought about we need to thought about the competition law for data protection and data protection law for competition. So those two laws are different and their objectives are different, but still there are some kind of overlaps, especially when you think about German Facebook case, also the Italian Google case. So we have seen some overlaps in Europe. Both are like exploitative abuse and also the exploitative abuse. So in the near future, we Koreans will face this kind of the issue. So we think about the European case, and because we don't have any DMA yet, so that's my argument. So exactly 5 o'clock. So I spent 1 hour. So we're gonna have a Q&A. Thank you. The last point is like, thank you. 감사합니다 and ありがとうございます.